New Mexico Real Estate Principles Workbook, page 10. 16. The disposition made by the exchange company of timeshares deposited with the exchange program by owners eligible to participate in the exchange program and not used by the exchange company in effecting exchanges. 17. The following information which, except as provided in subparagraph B of this paragraph, shall be independently audited by a certified public accountant in accordance with the standards of the Accounting Standards Board of the American Institute of Certified Public Accountants, and reported for each year no later than July 1st of the succeeding year. A. The number of owners enrolled in the exchange program and the relationship between the exchange company and owners as being either fee-paying or gratuitous in nature. B. The number of timeshares, projects, or other properties eligible to participate in the exchange program, indicating those having a contractual relationship between the developer or the association and the exchange company, and those having solely a contractual relationship between the exchange company and owners directly. C. The percentage of confirmed exchanges, which shall be the number of exchanges confirmed by the exchange company divided by the number of exchanges properly applied for, together with a complete and accurate statement of the criteria used to determine whether an exchange request was properly applied for. D. The number of timeshares or other intervals for which the exchange company has an outstanding obligation to provide an exchange to an owner who relinquished a timeshare or interval during the year in exchange for a timeshare or interval in any future year. And E. The number of exchanges confirmed by the exchange company during the year. And 18. A statement in bold-faced type to the effect that the percentage described in subparagraph C of paragraph 17 of this subsection is a summary of the exchanges properly applied for in the period reported, and that the percentage does not indicate the likelihood of confirmation of a purchaser-specific choice or range of choices, since availability at individual locations may vary. The developer shall obtain the purchaser's written certification of receipt of the information required by this subsection. B. The information required by paragraphs 2, 3, 13, 14, 15, and 17 of subsection A of this section shall be accurate as of December 31st of the year preceding the year in which the information is delivered, except for information delivered within the first 180 days of any calendar year, which shall be accurate as of December 31st of the year 2 years preceding the year in which the information is delivered to the purchaser. The remaining information required by subsection A of this section shall be accurate as of page 11. Date, which is no more than 30 days prior to the date on which the information is delivered to the purchaser. C. In the event an exchange company offers an exchange program directly to the purchaser, the exchange company shall deliver to each purchaser concurrently with the offering and prior to the execution of any contract between the purchaser and the exchange company the information set forth in subsection A of this section. The requirements of this subsection shall not apply to any renewal of a contract between a purchaser and an exchange company. D. All promotional brochures, pamphlets, advertisements, or other materials disseminated by the exchange company to purchasers in this state which contain the percentage of confirmed exchanges described in subparagraph C of paragraph 17 of subsection A of this section must include the statement set forth in paragraph 18 of subsection A of this section. 47-11-9 Service of process on exchange company. Any exchange company offering an exchange program to a purchaser shall be deemed to have made an irrevocable appointment of the Commission to receive service of lawful process in any proceeding exchange against the exchange company arising under the New Mexico Timeshare Act. 47-11-10 Securities laws apply. The Securities Act of New Mexico shall apply to timeshares deemed to be investment contracts or to other securities offered with or incident to a timeshare. Application for registration of timeshare project, denial of registration, renewal, reinstatement, termination of developer's interest. A. Prior to the offering in this state of any timeshare located in this state, the developer of the timeshare project shall make written application to the Commission for the registration of the project. The application shall be accompanied by a fee in an amount fixed by the Commission based upon the number of timeshares to be offered for sale, but not to exceed $1,500. The application shall include a description of the project, copies of proposed timeshare instruments including disclosure statements, sale contracts and deeds, information pertaining to any marketing or managing entity to be employed by the developer for the sale of timeshares in the timeshare project or for the management of the project. Information regarding any exchange program available to the purchaser. An irrevocable appointment of the Commission to receive service of any lawful process in any proceeding against the developer or the developer salespersons arising under the New Mexico Timeshare Act, and any other information or documentation required by the Commission. Upon receipt of a properly completed application and fee, and upon a determination by the Commission that the sale and management of the timeshares in the timeshare project will